All right, let's pick up where we left off, Mr. Ohm. If you could continue with the
Okay, so Mr. Klein, you were discussing this backdoor that you found.
Yeah,
what did you do next in the proceeding?
So I looked at this SQL data program and started running some various commands against it to see if I could determine what it was that I was looking at here. What I also did was Agent Carroll had done ran the gcore command against every process on the system. And in effect, what that does is it takes a core dump snapshot of every process so that I can run a debugger against it to see what data was in it, maybe what strings were in it, what kind of program it was. So after running several different programs against both the core image and the SQL data, I discovered some interesting attributes about the program, and I'd like to move to Defense Exhibit 13, please. So I ran the strings command against the core file, and if you'll notice, one of the strings in there is rlogin, and what rlogin or rlognd, and what rlognd is, it's an old Berkeley command for a remote login daemon. So it actually allows a remote login client to connect to it to be able to establish remote access into the machine. In addition, I also ran the strings command and I looked for volD, which is the Solaris volume manager, and I found the volD string in the core image. I ran the same commands against SQL data, and as you can see, I found the same strings there.
So it appears, if I'm following, that this thing had two different names at two different times. Is that right?
Correct. So what you had, and I believe what we have here is you had a program called SQL data that most likely re-executed itself and changed argv0, which is the name of the program, and called itself volD when it re-executed itself, so that when Agent Carroll ran the PS command, this showed up as volD rather than SQL data.
Okay, and so you've talked a lot about how you found this. Could you determine at all what this program did?
So I wanted to run an experiment in my lab. I took another copy of the system and I booted it up on similar hardware that was run at the at CMO, and I waited till the 0 hour for the cron job to kick off. I verified that port 33003 was in operation, and I started trying to send data to the program to see how it would react. And what I discovered through my tests is that this was indeed an rlogin program, but whereas you would normally be required to authenticate with a user ID and a password, this would just allow me to connect through port 33003 and immediately establish a shell on the remote system.
So at the risk of insulting the judge, who has been 2 steps ahead of you the entire time, what did this tell you about what happened in this case?
So my expert opinion, I feel that somebody deliberately put this backdoor program on the machine and attempted to hide it and then later use it to gain remote access privileges no matter what the root password was.
And then more to the point, what are you prepared in your expert opinion to say about how this impacts the case against Brian Martin?
So in my opinion, this means that someone else could have gained privileged access to this machine.
So Your Honor, there's our proffer. And we believe that this is disclosed in the expert report, and we would like to testify in front of the jury.
All right, Mr. Bankston, do you have any questions? Would you like to probe a little bit factually?
No, Your Honor, I'd just like to renew my objection and point out this is obviously very complex evidence, yet we only received this morning. He says 24 hours, maybe that's when he dropped it in the overnight. But we only saw it this morning. We've had absolutely no time to prepare any kind of rebuttal for this witness.
But Your Honor, this is fundamentally critical to the entire case. If you look at the original expert report, page 9,233, there's a sentence that says, I looked for vulnerabilities on the machine. I think that's adequate disclosure for the proffer that you've just heard. And we supplemented it a little bit this morning, that's true.
All right, well, look, Mr. Bankston, do you have a response to that?
Your Honor, that one single sentence in no way gave us any indication about this testimony.
Yeah,
it didn't even reach any kind of
conclusion. But that's my thoughts exactly. Let me ask you a little bit concerned about the probative value of this. I understand there was some voodoo here that was very impressive, but it sounds as though the bottom line is that you found a way into the machine to gain some sort of user-level permissions.
To actually gain administrative access.
Did your forensics analysis reveal that that had ever actually been used?
No, Your Honor, there
Okay.
was no data.
And did your forensics analysis indicate who had put that back door there?
No, Your Honor, it did
All
not.
right, it could have been a system administrator, I suppose.
It's
All
very
right.
possible, sir.
I do see the value of this. I don't know that it's critical as you have stated, but I do see some value as a defense theory as to why you'd want to offer this. I also see that this is precisely the type of testimony that the pretrial discovery rule for expert testimony was intended to cover. So I'm inclined to agree with Mr. Bankston on precluding admission of this evidence, but given that this is a criminal case and that your client's liberty may be at stake, I am willing to consider perhaps delaying the trial so that the prosecution can have a chance to analyze the report and perhaps duplicate or attempt to duplicate the results. And in that way forgive the failure to disclose pursuant to
Your
the
Honor,
rule.
I just would strenuously ask that you reconsider. You're basically cutting us off at the knees. We've all prepared for this trial. We're all ready for the trial. The witnesses are arrayed. The inconvenience to us all would be astronomical. And by the way, I will remind you that my client's liberty is at stake here, Your Honor. We want to get this resolved as quickly as possible. So I ask you to reconsider and allow this testimony.
I will allow the testimony if we give the prosecution some time to be able to correct the error that was caused by the defense. And I think that's the only way we can proceed. So, counsel, I give you the choice. You may either proceed today and continue the trial without the evidence, or we can delay, and we'll find some time on my calendar to try the case again.
Your Honor, I just don't know what to do with that decision. I want at least the record to reflect we're very annoyed. And I think with the options you've given us, we're going to just have to proceed with this witness.
All right. Well, you've made your choice. I will say that the testimony, the opinions on this point will not be allowed. You shall not pursue that with this witness. If you have a lay witness that can testify to the same points that's not covered by the rule, we would, of course, allow that subject to the other rules of procedure here. But we'll now bring in the jury, and to the extent you have any questions, do you have questions?
Yeah, I absolutely do. And Your Honor, for clarification, the witness is still authenticated as an expert in network techniques and strategies, and we intend to ask a few questions in those lines.
All right. We will continue with the questioning, and Mr. Bankston, if you find that the testimony goes into areas that have not been adequately included in an expert report, timely submitted, I would rely on you for notifying the court on that. But now that the jury has stepped in, let me instruct the jury that the last question and answer that you heard, you shall disregard as though you never heard it, and it will not be considered in your deliberations. Mr. Ohm, if you would continue.
Yes, Your Honor. Mr. Klein, did you look at moral decency, this program that was discussed earlier?
Yes, I did.
What did you conclude about this program?
Well, it's my opinion that if Mr. Martin was looking to stop pornography coming through his network, again, I may not have exactly written the programs exactly as he did, but I don't want to second guess his capabilities as a programmer. I'd still say it would be a pretty standard technique to look at the traffic, look for pornography, and to isolate those particular messages for later review, whether it's for criminal referral or whether it's a policy violation internally.
Okay, thank you. No further questions.
Do you have any cross-examinations?
Yes, just a few questions, Your Honor. So you say it's fairly typical for systems administrators to engage in this kind of filtering?
Well, most likely for internal users, but not necessarily for guest users. I typically try to get my clients to at least put together a system monitoring policy that guests are allowed to see or should see and should accept that says your traffic's going to be monitored for content, and you consent to that in wanting to use this network.
And it's such notice and consent that's actually typical, correct?
Correct.
All right. And as far as filtering all the traffic on a network looking for files that contain particular colors, is that typical?
No, not really. I mean, because looking for colors, it's very difficult to be able to have the program distinguish a pornographic picture from a sand dune.
Have you ever seen a sysadmin run a filtering system of this nature?
No, I have not.
Thank you, Your Honor. That's all I have.
Any redirect?
Just one question, Your Honor. Child porn, does anyone ever filter for child porn?
Absolutely, they're filtered for child porn because possession, even possession of a single image, could be considered a federal offense.
Thank you, Your Honor. No further questions for this witness.
Any further questions, Mr. Bankston?
No, Your Honor.
Mr. Rohn? Do you have any, may I dismiss the witness?
Yes, you may.
All right, you're
Thank you, Your
excused.
Honor.
Thank you for your
Thank you,
time.
Your Honor.
You have another witness, sir?
Yeah, I believe her name's Samantha Jones, but I'm blanking right now. Oh, good. Okay, I'll call Samantha Jones to the stand, Your Honor.
Ms. Jones, do you promise to tell the truth, the whole truth, and nothing but the truth?
Before God, yes.
Please have a seat.
Good evening, Ms. Jones. How are you?
Fine, how are you?
Not bad. Could you please state your name, title, and job responsibilities for the record?
My name is Samantha Jones. I'm the CISO of the Center for Coalition for Moral Order, and I've been with them for 10 years. I have certifications in security of MIS, ISS, and IPPI.
Okay, very well. And what are your job responsibilities as the CISO?
My responsibilities are to make sure that our systems are secure, that our IT infrastructure is secure, and that we have a decent network that reflects the values of our executives.
So could you elaborate on that? What do you mean decent network and the values?
We want to make sure that nothing appears on our network that will create a hostile work environment, and based on our ethical principles, that includes pornography, indecency, harassing material, any kinds of, sexually explicit information.
So aside from having this as your goal, do you relay this to the employees at the company?
We certainly do. We have an acceptable use policy that details all of the methods that we expect from our users, all of the compliance issues.
And could you turn to tab 16 in the binder in front of you? Do you recognize this document?
Yes?
It has something to do with what we were just talking about. What is this document?
This is our acceptable use policy, or a redacted section of our acceptable
Okay, could
use
you read
policy.
the bullet point to the jury that we've highlighted on the screen, please? Oh, Your Honor, I would move the
Is there any
Exhibit 16.
objection to the witness reading this exhibit, sir?
No, Your Honor.
Go ahead.
I'll have to go out and see it.
Feel free to leave the witness stand.
Okay. Thank you. Users are strictly forbidden to download or store any form of pornography. CMO monitors the network to ensure all data stored is appropriate for our family values reputation. Any activities that may put CMO's reputation at risk will result in immediate dismissal.
Please do.
So we've talked about your policies. What steps have you taken to achieve these goals, aside from writing the policy?
We also hired a systems administrator that was informed of our value code. We had previously interviewed another administrator, a Mr. Space Rogue, but found that he didn't have the moral character that we were looking for.
I see. Okay. And who is your systems administrator?
Our systems administrator is Brian Martin, and we communicated our goals by showing him our acceptable use policy and in the interview process and in our new hire letter.
Okay, and again, if you could turn to tab 3.1415. Do you recognize this?
Yes, this is a copy of our new hire letter to Mr. Martin.
And Your Honor, I would like to move this exhibit into evidence.
Any objection?
No, Your Honor.
I believe you've marked this as Exhibit 17.
Okay, my document just says X. Okay, Ms. Jones, what is this? Could you read this to the, jury? Yeah.
May I
Make,
approach?
Your Honor, leave
Please do.
for the witness to approach the screen.
Dear Brian, the Coalition for Moral Order is pleased to offer you the position of Systems Administrator with a start date of August 1st, 2005. Your starting compensation will be at an annual rate of $65,000. As we discussed, CMO's primary goal is a return to moral decency. Please remember that our mission is to bring back family morals and help us achieve those standards. You're expected to maintain the systems in a secure manner free from offensive material. If you have any questions regarding the conditions of your offer, please feel free to contact me. Sincerely, Samantha Jones.
Thank you, Ms. Jones.
Please sit down, then.
So what in your knowledge, what did Mr. Martin do to affect these policies?
Well, I just simply told him the high-level view of what I needed to be done. I'm not a technical person, and I don't get involved with the bits and bytes.
Okay.
So it was up to him to decide, to figure out how to implement this.
Were you aware that he was using something called packet sniffing technology?
Well, again, I didn't know the details of the name of the programs, but I knew that he was using something, yes.
And how did you find out about that?
Mr. Morton would bring me reports of his investigations on a regular basis, and I would review these reports with him.
Okay, so could you elaborate a little? What do you mean investigations?
We had 2 incidents where 2 of our employees were trafficking in objectionable material, and we ended up investigating this. His detailed records showed the images, showed the IP addresses from the employees, and this was used with HR to dismiss them.
Do you remember what the images, the nature of the images, basically?
They were pornographic images.
Pornographic images. Okay. And did you, so to bring this administrative action, did you use the images that were actually?
We used the images as proof to HR, and we retained them in our archives for legal purposes. We didn't want these kind of images on our network, and I was appreciative of Mr. Martin taking care of this in a proactive manner to avoid a hostile work environment for our decent employees.
Great, thank you. No further questions.
Do you have any questions, Mr. Banks?
Yes. Not sure where to start. Hi, Ms. Jones. Thank you for being here. As an initial matter, are you aware of anyone but the defendant having administrative or privileged access to your network?
No, I was not.
Okay. So you mentioned this incident with 2 employees. I'd just like to clarify. The conference was attended by many non-employees as well as your own employees, correct?
Yes.
You also mentioned that these 2 employees had images that were pornographic, were trafficking in these pornographic images. I'm wondering, do you have any training, or does your staff have any training in distinguishing protected sexual speech from illegal obscenity or child pornography?
No, we don't condone any pornography whatsoever.
Yes, okay, that's unsurprising. So is it fair to say that the reason you have this policy in your acceptable use policy regarding inappropriate material is because you and your organization morally object to such sexual content, pardon me?
Well, of course, this is my view, but it is also the view of the organization I'm proud to represent.
Okay. Were you aware at the time of the conference, let's back up actually, did you instruct the defendant to monitor the traffic at the conference using his, moral decency sniffer filter combo?
One of the aspects of Brian Martin that I've always appreciated is that he does not need explicit instructions. He is very proactive in his work and very conscientious.
Mm-hmm. Were you aware that he was doing this at the time?
Not explicitly at the time.
Okay. Did the conference attendees consent to this monitoring in any way? Let me clarify. Did they see this acceptable use policy that made clear that communications may be monitored?
I'm not aware that they saw it. It would be logistically difficult to distribute this to 3,000 attendees.
So neither you nor your organization distributed this acceptable use policy to the attendees?
Well, no.
No, thank you. Did the attendees sign any form consenting to the monitoring of their communications?
Well, again, logistically, that would
yes
be
or no,
difficult,
please.
But they should have known they would be
yes
monitored. This is America, after all.
Objection, Your Honor. Conclusory, she is not a competent witness on this subject. It's irrelevant.
Are you asking for the testimony to be struck?
Absolutely, Your Honor.
Your Honor, I'd ask you to take judicial notice that that's a known fact that everyone knows.
If it were, we wouldn't be having this trouble with state secrets in our case. But anywho, we're off track a bit. I'm sorry, did you rule on
What
that
more
objection?
than striking the evidence would you like me to do, Mr. Banks?
No, I was asking if you had struck.
I have struck.
Thank you very much, Your Honor. So no signed consent. Was there any banner when people logged on indicating that they would be monitored? Yes or no?
No.
Signs on the walls?
No, it's a good idea.
Any announcements that were made during the conference?
No.
So you are aware of absolutely no notification to or consent from the conference attendees regarding the monitoring of their communications, correct?
No.
One last question. Are you aware of any pictures that are so dirty that by virtue of their dirtiness they could crash a network?
Objection, Your Honor.
What's the basis for the objection?
That's just a crazy idea. I've never heard such a thing in my life.
I'd like her to say that it's a crazy idea.
Yeah, you can answer the question.
Are you aware of images that by their content being immoral or dirty, that would affect the security of a network?
As I said, I'm not that technical, so I'm not sure. Should be researched.
I have no further questions, thank you.
All right, any cross?
Just quick question. Redirect. Quick questions. So, when you found out about this, the occurrence with the senator, what was your reaction?
I was shocked, of course, because I was acquainted with the senator and was not aware of this aspect of his personality.
Okay, but in particular with your employee, Brian Martin, what was your reaction to the fact that he was accused of doing this?
I'm sorry, objection. What's the relevance of this?
It goes directly to your questions about the conference and whether or not there was consent.
Yeah, we'll allow that.
Okay.
Even though I did not know explicitly, I certainly didn't mind. It's my network, and conference attendees shouldn't be surfing porn. They're here for a conference on moral decency, so I approve that he was carrying out our goals and our policies.
And did you discipline Mr. Martin for this?
No, I did not.
Thank you. No further questions, Your Honor.
Okay. You may be excused. You have any other witnesses?
Yes, Your Honor. The defense would like to call Mr. Brian Martin to the stand.
Guys, please.
Mr. Martin, would you raise your left hand? Do you promise to tell the truth, the whole truth, and nothing but the truth, which is honor?
I don't see the Ten Commandments.
Do you agree to be under oath, Mr.
Yes,
Martin?
sir.
Please have a seat.
Good evening, Mr. Martin.
Hey,
Hey. Could you please state your name and your job title for the record?
Brian Martin. I'm a system administrator for the coalition.
And how long have you been at this job?
I'm almost 1 year now.
Could you tell the jury what your job entails?
I'm kind of a jack of all trades. I maintain all the systems, make sure the network's up and running, monitor for security incidents, take care of any other problems that may arise.
And elaborate a little, what types of problems do you take care of that might arise?
Oh, everything from people trying to break into our network to deface our page, any kind of illicit material that's sent across the network, I have to look for and make sure it doesn't happen.
And what do you mean by illicit material?
Anything that doesn't fall within the principles of our organization, there's just a lot of bad stuff going around these days, and our coalition doesn't think it should happen on this network.
So what made you think that this is what your employer wanted you to do?
Well, she was pretty clear during our introductory meeting and the job offer and all of her direction after that.
Okay.
She said to stop bad things, and I did.
Great. And please tell the jury what you did to stop bad things.
Well, everything from monitoring the network traffic to looking at logs, any kind of suspicious behavior, anything that stood out as not falling within our guidelines or anything breaking our acceptable use policy.
So what's Flesh Reader?
It's a little script I wrote. Basically, it monitors all the traffic looking through images at the colors and pulls out anything that might be suspicious that would fall under the category of pornography. I find a lot of the commercial solutions just don't adequately do their job.
Okay, and so this will detect pornography on the network?
Yes.
And what do you do when you find pornography on your network?
Well, the program automatically saves a copy into a directory, and due to my job duties, I don't always have time to review every single thing that it saves, but it saves a copy just in case we need to initiate any kind of disciplinary action or legal proceedings.
So have you had to do that in the past?
Yes, we've had 2 employees that have kind of gone a little out of bounds. Both resulted in termination. One of them was Miss Alder, the other Mr. Sulo.
Okay, and again, did you save these images after you discovered that they were there?
Absolutely. That was the beginning of the document trail that HR needed to start the process for termination.
Okay. And then Does Flush Reader, what does it do when it hits something that's not pornography?
Well, like anything else, it's going to save a copy until it can be reviewed by the administrator, me, and...
No. What does it do if it finds something that's not pornography?
Well, if it's truly not, if it doesn't match any of the signatures, doesn't have any of the characteristics, then it discards it and doesn't save a copy.
So why did you configure it that way? Why does it discard it?
Well, if it's not pornography, then pretty much accept that it's going to be a normal image, a joke, some kind of humor or whatever, and it's allowed to go out on the network.
Okay. So turning to why we're here and the incident with the senator, of course, were you informed at some point that Flush Reader had saved these images?
Oh, eventually I was, when Agent Amateur over there finally kicked down my door.
And so what about prior to that? You had no idea that
Absolutely not, no.
Okay. And why not? I mean, these were saved on your system. Why didn't you know they were there?
Like I said, my job duties, they have me working long hours, and I don't always have time to go back through the logs or to read look at all the images that are saved.
Did you see the article when it came out?
After it was published, yes.
Okay. And so the first time you discovered the email, you said, was when Agent Carroll appeared and told you that this was there.
Agent Asshole, yes.
Objection.
Yes, Mr. Rome, you control your witness.
Sorry,
Sir, please, no profanity in this.
I'm sorry, what was his
esteemed
name?
forum.
Agent Carroll is...
Oh, Carroll,
Yes,
sorry.
okay. So what did you do after the beginning of the investigation with respect to these files?
I cooperated as much as I could. You know, I gave him answers to all of his questions, and that's when I learned about the images.
What did you do with the files that were on your system?
I didn't really have a choice. He took copies of everything. Once I reviewed them, saw what they were, I deleted them, because I figured that, you know, what had happened was obviously punishment enough for him.
And did you send copies of those to anyone else?
Absolutely not.
Do you know a man named Ryan Bulett?
Yeah, he's a journalist. He writes about all kinds of stuff around the D.C. area, and yeah, I've read his stuff.
Okay. Did you send any email about the senator or the conference to Ryan Bulett?
No.
Did you send anything to Ryan Bulett in the last 6 months?
Maybe about 6 months ago, complimenting him on an article, but nothing recent.
Okay. So you did not courier this faxist, you did not send it?
Absolutely not.
Thank you.
Any cross-examination?
Yes, Your Honor. Mr. Martin.
What?
So, through the operation of your Flush Reader filter, you've accumulated a great deal of images, I suppose?
Sure.
That collection of images would include a great number of photos that are not by any stretch pornographic, wouldn't they? We've had previous testimony about sand dunes and family photos.
He said that might happen. There's been a handful of images across the time that wouldn't fall into the pornography category, but most of them that have been captured are definitely questionable or come close enough to the acceptable use policy that we don't want them on our network.
So you actually have quite a prodigious collection of pornography, don't you, Mr. Martin?
No. Once the images are reviewed, HR is notified if necessary, or the images are deleted.
Okay. Have you ever made personal use of any of the images in this database, Mr. Martin?
Absolutely not, and that's offensive. I'd like to object to this.
I'm sorry, but it's quite relevant to the use charge. So this Flush Reader system, you were running this during the SMOOT conference?
Absolutely. It's run at all times on our networks.
And therefore, the system was acquiring all of the messages and filtering through Flush Reader and anything that had a particular percentage of fleshy hues?
Yes.
Was collected?
Yes.
Okay, so, and you admit that this system intercepted and stored the senator's emails and his photos?
I found out later that they did.
Okay. Did you use the filters? Did you personally monitor the output of the filtering system during the conference?
No, I did not.
So your use of that filtering system did absolutely nothing during the conference to prevent any misuse of your network?
Technically, no. It didn't stop at real
I'm sorry,
time.
yes or no? Did that system prevent misuse of your network during the conference?
Technically, no.
Thank you. And I guess there was no deterrent effect from the use of that system because you never told the attendees that it was being used, did you?
That's in the acceptable use policy.
Was the acceptable use policy distributed to the attendees?
I don't know. It's not my job.
Are you aware of anyone having notified or obtained any consent from any of the conference attendees?
Isn't it common sense that anything you send out on wireless is going to be read by everyone?
Objection, non-responsive.
Would you please answer the question?
That is an answer.
Are you aware of anyone in your organization having notified or gotten the consent of any of the conference attendees to have their traffic monitored by
3,000 people?
CMO?
No, I don't.
Yes or no?
I don't know. I don't think they did.
Okay. Earlier when you were asked about Mr. Bulette, you said you admired his work.
Yes, he writes very good articles.
More than admiring him, you've actually repeatedly sent him email, correct?
2 or 3.
2 or 3. Okay. Is it 2 or 3 or more? Do you know? Do you know how many emails you've sent him?
More than 1, less than 4.
Thank you for your precision. And in these more than 1, less than 4 emails, did you send Senator Gism's emails and pictures to the reporter, Mr.
Absolutely
Bulette?
not.
You didn't. So you claim you didn't send these emails. Let's move on and talk about your relationship with the senator. It's fair to say you're a longtime supporter of Senator Gism?
Formerly.
Formerly. In fact, you've worked as a full-time volunteer on all of his previous campaigns, have you not?
Not all, most of them between jobs as time permitted.
Okay, and you've regularly contributed to his campaigns?
10% like a good citizen, yes.
And that's because you support his views on moral purity and order. Is that not correct?
Yes, moral purity.
Indeed, you feel so strongly or felt so strongly about your support for the senator that you, during the 2000 campaign, got a tattoo with the words Gism Forever 2000 on your left buttock. Is that not correct, Mr. Martin?
Proudly displayed it at some of his rallies to his opponents.
So I bet you were pretty darn disappointed when you saw these photos that were published in the Washington Compost.
Disappointed just like I am in the legal system.
The jury will disregard the slight to the judicial system.
So you were more than disappointed, weren't you? You were pretty darn angry, weren't you?
Yeah, I was a little angry.
And so you're glad now to see the senator's hypocrisy exposed, aren't you?
I wouldn't say glad. I would say that justice has been done through his own actions.
I don't think I have any further questions.
Good.
Is any redirect?
Yeah, I have a few questions, Your Honor. Mr. Martin, so why didn't you look at these pictures during the conference?
Way too much to do. The hotel screwed up the network. There was too many computers trying to sign on. It ended up being a lot busier. Just had way too much on my plate. Didn't have time to actually look through any of the stuff that the program had collected.
So is it any good to keep pictures from the conference if the conference has already ended?
Absolutely. If at any time down the road I have a chance to look through the directory, we can tell which members were sending pornography. And even though we couldn't stop them during the conference, we can make sure that they're not invited the following year.
Okay. Did you send the pictures to Ryan Bulette?
Oh, absolutely not.
Thank you, Your Honor. No further questions?
Any additional cross-examination?
No, Your Honor.
Mr. Rome, do you have any more witnesses?
I don't. The defense rests.
Sir, you're excused.
Your Honor, that's my final witness. The defense now rests.
Thank you. The defense rests. Ladies and gentlemen of the jury, you've now heard all the evidence. What was going to happen next is you are going to be hearing closing arguments, first from the prosecution, then the defense, and if the prosecution likes to or desires to reserve a little time for a secondary close, he will have that opportunity. Once the closing arguments are made, I will instruct you on how to determine the facts in the case and the questions that are presented to you. You will deliberate, and then once you've been able to, if you are able to reach a verdict, we will reconvene at that time. But we'll move now to closing arguments with Mr. Bankston.
Thank you, Your Honor. I'm moving fairly quickly this evening. I'm going to try and stick with that trend. Because I think this is a fairly open and shut case. The defendant has admitted that the software he installed did intercept Senator Gasm's emails, that it was intended to do so, that it was intended to indiscriminately collect all of the traffic on that network, the conference network, not the internal network, and then to be passed through a filter that, among other things, collects innocuous images that would never raise any specter of liability. Of course, even if there were a specter of liability, no one on CMO's staff would know that, because they can't even identify what is legal and illegal content. There is nothing accomplished by this surveillance regime. They admitted that it did nothing to maintain the security of the network while it was running during that conference. It served no legitimate purpose, other, and this is not a legitimate purpose, to enforce the moral values of the provider. Now, the law is clear. Interception is a crime. And the providers do have a narrow exception that the court will instruct you on, such that they can work to maintain their service. They can work to keep the system secure and protect their property and their legal rights. But we're not talking about legal rights here. We're not talking about protecting their property. We're talking about them imposing their moral values on their users through comprehensive surveillance without any kind of notice or consent from any of the people being spied on. I think that if you were to accept what is going to be clearly the defense's argument, that a provider has the right to do this, then the exception swallows the rule. Where does it stop? If a provider dislikes arrows, can they filter for Arabic containing messages? If they dislike the color blue, can they filter for messages that contain that offensive color? I would say no. The law would say no. So clearly, the defendant has committed the crime of interception, and in particular has intercepted Senator Gism's emails outside the provider exception, which leaves us with the charges of use and disclosure. The defendant admits that his sniffer and flesh eater software combination, moral decency, intercepted and stored copies of the emails and photos of the senator. There's no evidence that anyone but the defendant had access to these photos other than the senator and his aide, Ms. Lovelace, who would both testify that they shared with no one else. And the defendant, the only person with access to these photos, is well acquainted with the reporter who then shortly after the conference published them. A reporter who refuses to deny that they were provided by the defendant. I think that's an open and shut case. Admittedly, it is circumstantial evidence. We do not have direct evidence of that disclosure. But as the court will instruct you, you must consider circumstantial evidence just as you must consider direct evidence. So in conclusion, I pray that the jury send a strong message to those segments who think they are above the law. Send a clear message that if you want to sniff someone's content, you better, and forgive my French, have a damn good reason, and convict the defendant of interception, use, and disclosure of Senator Gism's. Thank you.
Mr. Ohm. And Mr. Ohm, if you would like to use a microphone, your comments will actually appear in the record.
Thank you, Your Honor. I have no idea why the prosecution just talked about pink elephants for 5 minutes. It's as inexplicable to me as it is to you. The last point that I want to start with the last point that he made, which was that he used these words circumstantial and direct. And as the judge is going to instruct you, two of the crimes that my client is accused to have committed include the use and the disclosure of this information. The use and the disclosure. My client has testified that he did not use these photos. He did not disclose these photos. There is no direct evidence. The reporter didn't testify at all about who his source was. There's simply no direct evidence, and what the prosecution basically asks you to do is pile inference upon inference upon inference to say that the use and the disclosure were his. So that leaves us with the interception charge, which is the charge that the judge is going to describe the elements to you. And what I want to say about that is, remember the ancient maxim, a man's home is his castle. And what does that mean? You all have familiarity with that. You are allowed to protect your home. You are allowed to protect your property. You're allowed to protect your rights. If you're in your home, you have special and recognized rights in protection. And so the question is, for you, the jury, is the network your castle? And luckily, the judge is going to instruct you that the law has already supplied an answer to that. This law says that you are allowed to do monitoring if it's a necessary incident to protect your rights and property. The judge isn't going to tell you what those terms mean because we trust you, the jury, to divine the meaning of that. What does it mean to say that you are allowed to protect your rights and property? Well, there's two competing views that are being presented here. The government wants you to believe that those words, rights and property, have a cramped, narrow, constrained view. That rights and property, the idea that your network is your castle, is something that's limited to a tiny list of things. And don't be distracted by comparisons to Arabs in the color blue. I think you well know that that's not what we're talking about in this case. So what did my client, what did Mr. Martin do in this case? He was scrupulous. He was protective. He knew that this is what his employer wanted him to look for. He only looked for pornography. Now, granted, sometimes his program didn't work perfectly, but it did work a lot of the time. And there were images in there that reflected pornography. He was scrupulous to make sure that immediately images that weren't detected as pornography were erased. He never saw those images. His goal was to accomplish what his boss and his boss's boss and his organization set out to accomplish. What would the government have him do? What would the government have him do in this awkward situation? The government really puts forth maybe three possibilities. Number one, he could go to the important people, the people with whom they have very delicate relationships, like the senator, and he could ask him for permission. He could say, look, Senator, respected Senator, please don't download pornography while you're here at this conference. Turns out that may have been the right thing to do in this particular case, but there are 2,999 other people, and I think we understand why they don't want to have that conversation. They could have allowed pornography to just flow freely on the conference. The government frames this as an issue of privacy, but is it really? Ask yourselves, does a conference have the right to keep pornography off of every laptop that's in the audience, to keep it away from the eyes of everyone else sitting in that audience? Perhaps they do. I'm not sure. That's for you to decide. They could have just offered no network at all. They could have told their attendees, we're very sorry, but for reasons beyond our control, we're not allowed to provide the internet. These are the three options the government would have you do. These are the three options they present to you. And remember, this isn't about the freedom of speech. The senator was free to send these messages from his home, from his office, a hotel, a coffee shop down the road. There are many, many other places he could have done this. What the conference is saying is, please understand, our network is our castle. We have the right to do this. We have the urgency to do this, and thankfully the law has given us the ability to protect our rights and property so that we're allowed to do this. After the charge, I ask the jury to please find my client not guilty of the crimes charged. Thank you.
Mr. Bankston, do you have any additional words?
No, Your Honor. I think the defendant's submissions speak for themselves.
Thank you. Members of the jury, you've now heard all the evidence. It's now time for you to begin deliberation once I give you the instructions on the rules of law that you're to follow. Rule number 1, the government has the burden of proof. The government must prove before you can convict that the defendant is guilty beyond a reasonable doubt. And if it fails to do so, the defendant must be found not guilty by you. Now, reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal case law, it does not require proof that overcomes every possible doubt. It's only required that the government's proof exclude any reasonable doubt concerning the defendant's guilt. If you think there's a real possibility that he's not guilty, you must give him the benefit of the doubt and find him not guilty. There are, generally speaking, two types of evidence. There's direct evidence, such as the testimony of a witness, and there's another type known as indirect or circumstantial evidence, and that's proof that is established through a chain of facts that point to the existence of another fact. As a general rule, the law makes no distinction between direct and circumstantial evidence. The law simply requires that you find the facts in accord with all evidence in the case, both direct and circumstantial. Now, you've also heard testimony from two witnesses who have been qualified as expert witnesses, and they've expressed opinions as opposed to stating what they have observed with their personal experience. In some cases, such as this one, scientific, technical, or other specialized knowledge may assist you in understanding the evidence or determining a fact and issue, and a witness who has knowledge or skill or expertise or training or education may testify and state an opinion concerning such matters. You are not, however, required to accept the opinions as truth. You should consider the opinion testimony just as you consider any other testimony in this trial. Let's talk about the substantive offenses. I'm going to give you the elements of the offenses that the defendant has been charged with. Number one, illegal interception of a communication. To find the defendant guilty of improperly intercepting communications, you've got to find that the prosecution proved beyond a reasonable doubt that the defendant, Brian Martin, 1, intercepted, 2, the contents of an electronic communication, 3, using an electronic device, and I'll define that in a moment, and that the defendant did so intentionally. An electronic device includes any device or apparatus, and it can be an electronic one, that can intercept an electronic communication. If you find that defendant Brian Martin intercepted the communications, but did so for reasons that will be described in a moment as an affirmative defense to protect the rights and property, then you cannot find the defendant guilty for illegal interception. But I'll describe that in more detail in a moment. Number 2, charge number 2, illegal use of the intercepted communications. To find the defendant guilty of improperly intercepting communications and using those communications, the defendant must prove beyond a reasonable doubt that the defendant intentionally used an electronic communication that was obtained through an illegal interception, knowing or having reason to know that the communication was obtained through an illegal interception. Illegal disclosure is the third count, and it's similar to the illegal use count. To find the defendant guilty of improperly disclosing communications, the prosecution must prove beyond a reasonable doubt each of the following elements. Brian Martin intentionally disclosed an electronic communication that was obtained through an illegal interception, and he knew or had reason to know that the communication was obtained through an illegal interception. Now, significantly, the defense here has asserted an affirmative defense, and this modifies the elements that I just described to you. The defendant has raised the affirmative defense that he was acting properly at all times because he had intercepted the communications as a necessary incident to the rendition of his service or to protect the rights and property of the provider. To establish this defense, the defendant must prove the aforementioned by a preponderance of the evidence, not by reasonable doubt. Preponderance of the evidence is sufficient if it is enough to persuade you that a fact is more likely than not present than not present. So it's not reasonable doubt, it's that the fact is more likely than not. If you conclude that the defendant has satisfied this burden, then the interception is not improper. In a brief moment, the bailiff is going to escort you to the jury room where you can begin your deliberations. One thing I want to remind you is that to reach a verdict of guilty or not guilty, you've got to agree unanimously. Your verdict must be unanimous on each count of the indictment. A form verdict's been prepared for your convenience. You will fill that out once you elect a foreman in the jury room. And the court will be in recess once you are escorted by the bailiff, but you can, of course, contact us through the bailiff. And with that, I thank you for your service and good luck in the jury room. The court is now in recess.
All right.
So we'd like to open this up for any questions you might have. Just to let you know, we actually rushed this trial pretty quickly. Normally this might have lasted several days, but unfortunately we have to cram this into a couple of hours.
Do the vote.
We're going to have a vote?
Yeah,
So everybody who thought Mr. Martin is guilty, raise your hand.
Say do it.
Yeah.
I'm sorry. On count one, improper interception. Well, you're not guilty.
Not unanimous.
I think you're down on the first one. So on count two was improper use.
Yeah, I think
An improper use. Not guilty. You're off the hook on number two. And on count number three, improper disclosure.
Same thing.
Not guilty. You're only going down for the first one.
Still going down.
Yeah, he's still going to the big house.
So, Your Honor, we ask you to please schedule sentencing. So as I said, normally this trial would probably have gone on a lot longer.
Weeks.
Well, it definitely would have gone on a lot longer. In one trial I testified in, my testimony went on for 7 hours over 2 days. I crammed mine in what, 20 minutes? It most likely should have gone 3 or 4 hours because, quite honestly, a jury of your peers is not you very technical people here. It's probably your grandmothers.
Was anyone stupid enough to get into jury duty?
Pretty much. And even if you're not stupid enough to get into jury duty, they won't pick you if you have even an IQ above 50. So I'd like to open this up to any questions from the floor.
I have a question for the defense.
Yeah.
Because I think there was a question you could have asked this CISO that would have let your client off the hook in my mind anyway.
Okay, what was that?
The defendant knew about the acceptable use policy, but apparently had no way of knowing which people that were using his network had signed it.
Right.
And at the conference, he had no way of knowing who had signed it. So
I mean, the age-old sorry to cut you off, but ignorance of the law is no defense.
But not in ignorance. As far as he knows, he's doing a lawful act. Why is he culpable for...
As far as he knows, he doesn't have anyone's consent. I think that's the main point.
He admitted that on the stand. That's the big flaw. Is
Right.
let your client admit that he didn't know who he had the right to...
I mean, the important threshold for this thing, and this explains some of the oddities in the way the case had to be structured, is Kevin and I, when we started talking about this case, we said we want to push the provider protection privilege. And so in order to do that, you have to make consent kind of disappear. And it's really hard to make consent disappear because there's always arguments I could have made about you're at a conference, you're on Wi-Fi, there are all these things that we push to the side. We wanted this to be about a pure provider protection motive that was a little gray. And so that explains that. You're right, I probably should have not had him say that, and there are probably other questions we could have done, but we had made a conscious choice to make this not about consent. Consent we were trying to knock off the table. But to address your point, I don't know if it's a proper defense, and I don't see if Rick or Kevin disagrees, to say that you had no idea whether or not people had consented. The crime is defined in terms of what you do. Consent is a defense, right? And we're not going to be able to establish that defense here. I don't know if that makes sense.
The one thing I want to point out is we take very great care with Hacker Court to keep the case very even so it could go either way. In reality, let's take the Southern District of New York where I do most of my work. The conviction rate is 97%, which means a lot of cases, there is no defense, you're going down. But that's not going to be very interesting to you guys, the audience. We try to keep it very even. In all probability, this kind of case probably wouldn't have been brought if prosecution didn't feel they had a slam dunk.
Who wasn't a senator?
Who wasn't a senator? Question?
Right. Again, and I'll let other people talk too, but this is a crime that requires intentionality. And so that's one of the reasons we had Samantha Jones say, I didn't really know what he was doing, right? I was kind of ignorant about the conference in particular. I think it's plausible that on these facts, the prosecution might think, we're not necessarily going to make our case against the CISO or the company, but this guy definitely did it intentionally.
I think there's certainly a civil claim against the provider here, but criminal, no one else knew about it. He was doing it on his own and hadn't told anyone. He was the only possible criminal defendant.
But she was aware that he was doing it.
Not to that extent.
Not until after.
Not at the time. She found out after the fact.
With the employees. With the employees.
The employees, but not
who
with
have
the
an acceptable
conference
use policy
attendees.
that tells them they're going to be monitored.
And I
So there's a
monitored
consent
my
argument there.
networks, and at the time, that conference network became my network. So,
Did you know that there were people that were using your network that were not employees?
Sure, yeah.
Would that be relevant?
Again, to the consent question, absolutely. To the consent
If
question,
he thought they were all employees who had the AUP, then we'd have trouble showing intent. But again, consent, the lack of consent isn't an element of the crime that the prosecution has to prove. It's a defense that they have to show. They have to show, no, really, I had the consent of people. And clearly he didn't have that. But on the consent issue, I want to point out, putting on my EFF hat a bit, it's horrifying how consent cures all and how easy it is to get consent for the most invasive crap imaginable.
Absolutely.
In terms of click-throughs, in terms of fine print contracts that come with your Comcast cable service, whatever, many, if not most of you, have consented to interceptions of all of your communications and don't even know it. There is an argument then that it's not actually effective consent, but, yeah.
Question in the back.
Actually, before you ask the question in the back, I've got a question that actually kind of ties into this. This was submitted, one of the written questions that came in, and I'm guessing it was probably directed at you, Kevin. It says, if the victim was an ordinary U.S. citizen using AT&T for phone service, would the U.S. government be as interested in taking on this case?
Well, demonstrably not. I mean, have you seen a prosecution yet?
well,
I think that question, which is a bit of a dig at the DOJ, although I'd take it more as a dig at their bosses. I would not be surprised if there are AUSAs who think a crime has been committed in terms of the NSA.
hang on, I gotta. With that question in particular, Kevin and I often agree on this stuff, but with that question in particular, they didn't mention the NSA. So if the question is if AT&T started doing this to their customers and the DOJ found out, as a former prosecutor, I would definitely have recommended prosecution. Richard Salgado and I were two of the prosecutors who worked on a case called US v. Councilman that you may have heard of, which involved a guy who gave email accounts to customers and, oh, by the way, read some of your email messages. And that's been prosecuted vigorously and at several levels of appeal. Yeah. So because the NSA wasn't invoked in that question, I think there's two ways to answer it.
I was actually about to bring up that very case as an example of, surprise, surprise, the DOJ, in terms of prosecuting these crimes, is a defender of privacy. And sometimes it causes strange bedfellows. EFF was an amicus in the Councilman case, and we got a lot of crap from people who were like, how are you going to help put this guy in jail? And it's like, he illegally intercepted all these people's emails so he could see what they were ordering from Amazon, because he was a competitor. It was a book dealer who offered his customers email service. And it's like, that could not be more of a felony. And there were some very important, interesting, hairy questions of law involved. But yeah, I mean, if you're wondering why is the EFF guy prosecuting, I think it's fairly clear the privacy angle here. And although we want providers to be able to do what's necessary to secure their networks, we definitely think that the provider exception needs to be read as narrowly as possible in order to preserve consumers' privacy against the people who control the networks they use.
So if I could then ask a question of the audience, especially for those of you who voted guilty on charge 1, was it because of this idea about rights and property? Could some of you volunteer and let us know if you think they went beyond rights and property, or was there something else about consent that you were going off of? What do you guys? Did someone who voted
was
guilty?
it it's my network, I can do what I want to defense, right. Or I mean,
because there's a counter argument to the CFF argument, which is when it's a private company network. Right? Forget about AT&T and their public customers, but private company network, your employees, maybe your visitors, maybe rights and property should let you do things like look for porn.
Yeah, I mean, notably,
I'm just interested to see if anyone at BlackHat, which is full of a lot of sysadmins, who frankly may be committing felonies every day, especially if your bosses haven't given you enough cover. What do you think about this? Where do you think this line, when Congress uses the phrase, you're allowed to protect your rights and property, what do you interpret that to mean? I'm just interested.
I'm from the Department of Defense, where banners and training and other elements pretty much quickly on notice that you will be monitored.
Mm-hmm. Consent is shown to them every chance possible.
Yeah, and so let's, if we put that aside,
I know that in the corporate does the law recognize common,
Right.
common practice as, and the lack of that common practice being an element in.
Another way of putting it is, does the law recognize the "you should have known better" argument for consent? And the answer is not really, surprisingly. The cases really say consent means consent. Consent means you've taken some act that shows that you were given the option to consent and you did. Now, that can mean clicking through a banner, that can mean reading a sign on the wall, maybe, but I haven't yet to see a case where a court says, you should have known better.
And actually, the idea of should have known better,
Yeah.
does it reflect on the sysadmin? Should he have known that he needs to do something?
Ignorance of the law, I mean,
Ignorance of the law is no excuse.
right, and that's what's going to
Yeah, I mean, and-
back on the sysadmin.
Sure.
With the case in point, you've got small conflicts. Actually, from the experience I'm hearing of some of the rights groups that are against one of small development, it's so far now the dirtiest networks out there. They're showing what small there is out there. So we'll actually warn these delegates. They're going to go and visit it to show how all of them dropped. So they expect it.
It is an irony that those who agitate most against porn have the best porn collections.
I just want a two-part question. In this particular case, if the system administrator has put up a banner to log in to his network saying your communication is monitored, would that be enough for consent to get him off the hook for count one? And the second part,
Almost certainly, yeah.
why did the defense not bring up the whole wireless issue?
Yeah, and we were, again, go ahead.
There's a reason for that. There's actually
Don't go into that.
Don't go in.
Go ahead.
It's short. It's an unanswered legal question, which is there is an exception to the interception prohibitions when the communications that you're intercepting were made over a system that is readily accessible to the general public. Yeah. And there's no case law on this yet, but there is an argument that could be made that wireless communications that are in the clear, that are not encrypted, are readily accessible to the public and therefore not protected by the interception laws. I wouldn't bank on that. If you're in a cafe and sniffing people's traffic, I'd ask you please don't. But it is an issue. But it was one that we didn't want to really get into.
It's not the same as facts yelling out you're in an open area, you yell something out, you're overhearing conversation, unless it's encrypted and breaking the encryption.
Yeah, I mean, I'm a privacy guy, so you're not going to get me to say any more than there's an argument that. But yes, there is an argument that. It's just free radio waves, man. Anyone can pull it down.
I got one question for everyone then. You have an open wireless network, let's say at the airport, and I connect to the wireless because I see, Denver Wi-Fi, and I know that I'm in an airport, it's expected I can connect and get free access. Most people load Internet Explorer, redirects them to a page, they have the acceptable use, whatever. I don't load my browser at all, I load SSH, I go straight to my mail client. What's the policy on that? I mean, they have technically put forth an AUP. They have asked for me to click I agree.
But you have not.
But I have not because I am a little more technically different than most of the people out there or whatever. So at that point, what's a court going to rule on that?
You didn't consent. That goes to the same point I was making. It's slightly different than the point I was making earlier,
Okay.
but courts don't read implied consent.
So that leads to my question.
You didn't see that banner, so you didn't agree to
On
it.
a technical level, how would any wireless network ever get 100% consent from users?
Am I wrong? This is me asking you guys a technical question. A lot of times with like the no-cat auth or whatever you use, isn't there a way to just stop all routing until they've consented on all ports?
How do I know that I have to load? Because if I load Firefox,
It just won't work.
Well,
It just
no.
won't work. You know what I mean? Your SSH would just stop.
So I would have to know not only to do that, I would have to know that I can't use Firefox or Opera. I have to load IE so that it will auto redirect, then find it, and only through those means.
But you're not on the network. That's the
then
important
click
point.
consent.
Yeah.
Then
Yeah.
I'm open to the world.
But what the fact that you're using SSH to create the icon, and therefore the information you're transmitting is encrypted,
There's still incriminating information just in my connection.
So there was a question in the back over here.
Just made a comment in response to the original question about why we don't
Okay.
charge. I work material that maybe you can't say you have a lot of computing policies per se. However, we don't do that because our faculty is very particular with regards to privacy laws, in terms of our personal privacy and in regards to rules. This is an interesting dichotomy that we're dealing with the academic. My question is this, though. General counsel is telling us we have the right to understand.
What school is that?
Maybe you shouldn't say. I advise you probably not to reveal
Could you
that.
take note of that?
Pass your business card up.
The question is, what do federal and state statutes allow in terms of doing what I call proactive
What state?
exception? I'm sorry.
Well, you said federal and state. What state are you in?
Pennsylvania.
Well, honestly, we presented it. This is a really accurate depiction of the law. The main thing that's shielding you without consent is your ability to protect your rights and property. And if your general counsel is that confident that he knows what that means and where that line is,
He's an idiot.
and one message.
This has not been litigated at all in the internet context.
One message that I used to do when I would go around and talk to sysadmin offices, people when I was a Department of Justice employee, was it was a little bit of an agitator, but I would say if your bosses are telling you to do it without consent, you may be committing a felony every time you do that. So you really may want to go to your bosses and say, I don't like you putting me at that kind of risk.
Yeah, I mean, I just keep in mind this really hasn't been litigated in terms of the internet. This originated with phones, and where it actually originated with was a common law defense that allowed the phone companies to pursue fraudulent use of their network, where someone had like a Whistler or whatever. I mean, I'm not a phone freak, but to try and track down people who were fraudulently using their network, not using their network to conduct fraud, but fraudulently using their network. And in fact, it's been fairly narrowly construed just to reach that here in the Ninth Circuit. And so how does that map to the internet where people are routinely sniffing an enormous amount of stuff? I don't know. I mean, I think viruses, you got a good, if you're reasonably narrowly tailoring the interception such that it's just going to, flag virus stuff, that's probably okay. But anything beyond that, anything beyond, trying to prevent fraud or trying to prevent stuff that would harm your network, I'd be very careful and get consent. And actually, I'd say, please don't get consent. That's mean. Don't force them to consent to that kind of crap.
Question here. Oh, I'm sorry.
Just a comment. I work for a European company, and so with regards to this consent, I mean, we require like written consent in some cases. Electronic consent's not enough. Like our German work council even had us stop our entire anti-spam deployment globally because a German employee could actually have mail that was not being delivered, albeit spam, to an employee anywhere in the world, potentially with a German citizen, until we got written consent from every single German employee. So, I mean, that's kind of the opposite of the position I'm saying. I mean, I think that for us anyway, our general counsel, we go full extreme. We have probably 15 processes in place for consent. And to me, that was what this case is all about. I voted for the first charge only because of consent. Everything else was just evidence.
Just a kind of hot question on the last point, which was, if you're talking about, viruses definitely is protection on my network, but what about things like I'm trying to protect my users from a phishing attack? Yeah. And I'm trying to filter out phishing websites that, well, it doesn't exactly.
I wouldn't do it without consent. I mean, really, bottom line, I wouldn't do any of this without consent. The good news for you is it's so easy to get consent. The bad news for me as a privacy activist is it's so easy to get consent.
But you're saying that hasn't really held up. That hasn't really been challenged.
No, it hasn't, but remember, it's always about cost-benefit analysis, and the cost we're talking about here is a 5-year felony. You're not going to get 5 years if it's a first offense, but that's what we're talking about. So,
I also think
just
practically, no jury's going to convict you for that. I mean,
no, not at all. Yeah, no one's going to prosecute you. In fact,
same with spam. I mean, you could do all the spam filtering you want without consent, even though you're like totally, digging your hands into the semantic content of these people's email. You're fighting spam, man. Everyone loves you.
Well, the caveat I'd put on that though is the case will come to trial when something goes wrong. When your filter's misconfigured and you open it up and you go, "Dear God, this is the vice president's letter to his mistress," or whatever. That's when the prosecutors are going to be a little more interested in what you did. So.
Question up here first. Yeah, back to the conversation about monitoring wireless networks. Would the locality of the sniffer be taken into effect? Because in this case, he went off the spam switch, as opposed to just sniffing in.
Or the locality, well, this would cross into federal sniffing across state lines. That would throw it into the feds court.
But I mean, I guess the question is, since he installed it, No, I don't think that would really affect the analysis.
I mean,
if the system's readily accessible to the general public, I mean, it either is or it isn't. But no, I don't know. I don't have a really good answer.
That'll be
It's really not regardless, right? If you're at a conference and there's a wire port in the wall, you could readily check in and get an IP address and serve. That's still really accessible.
No. It's not your connection that's readily accessible. It's are your communications readily accessible to everyone?
So I mean, it could be the same network, one network.
General public is the key.
The people who are using wireless, they may not be protected, but the people who are on the wire are.
Don't get us wrong. The wireless question is so shrouded in grayness.
And I'm not saying I endorse a particular view of it. Again, as a privacy person, I'd say I want the interception laws to fully apply to that jackass in the cafe who's trying to snip my password.
If at any point the court decides that there is an expectation or no expectation of privacy for wireless, then his question becomes fully relevant that the senator didn't expect his wireless communication to have any privacy, but all of a sudden I'm on the wire sniffing it.
Yeah, although, believe it or not, that's actually the law for electronic communications has nothing to do with reasonable expectation of privacy. That's a Fourth Amendment.
I know. I'm saying that if the court at any point ever says, hey, there is no expectation of privacy there, but there is on the wire.
I always like to say it turns on the facts. If someone's sniffing in a really malicious way wireless packets, if I were the prosecutor, I'd say, yeah, let's test this. Let's go after them. Let's indict them. Let's put them through the hell of being searched. I don't care if it was wireless. Let's throw it at them.
Moral of the story, don't be the first person caught doing this.
Yeah.
In terms of the protection of your network and things, would the protection of your company's reputation be something worth protecting?
Yeah, again, same question. Is that rights and property?
Is that a property interest? Do you have a legal right to your reputation?
Maybe.
I wouldn't suggest you rely on that.
Concept of slander, so clearly reputation is important.
You probably have a better argument than with porn. Well, with porn, there are also arguments about liability and things like that.
But if your organization is explicitly anti-porn, then disseminating porn from your network would be contrary to your corporate interest.
Yeah. So the question is rights and property. What does that mean? No one knows. Yeah.
Well, and again, I mean, in the context that it's been analyzed, which is the phone context, it's been narrowly limited to fraud prevention.
Would the argument have changed much? I know this was a complicated trial. If it pursued the idea that one of the photographs actually portrayed a crime in progress?
Technically, it did. That's a crime.
Well, there would have been an exception for the disclosure, probably. That would not have excused the initial interception.
Sex with sheep is a crime.
I mean, the after-the-fact content that you find after an interception's been done can't justify.
I don't see why. Yeah.
Okay, I got a question in the middle here.
Yeah, I think that one point in this case, how do we interpret the existing law in this digital life case? So let's think about the real life case. What if you invite people to your home, and they, without your consensus, they get interested and get too intimate? Do you have the right to take photographs? If you did,
That's an interesting hypo.
And there's also another question, like if you use flash and disturb these two guys,
Senator, would you like to
Stay away from that one.
Yeah, I mean, the reason, I don't know if that's exactly analogous, is because we have a law here. We have a written statute that says what you can and cannot do. You're talking about all the vague world of common law tort, probably, or maybe even criminal law, and it's not going to be as clear. And so I don't think the outcome there necessarily dictates the outcome here, right? The whole problem with internet law is choosing the right analogy, and it's always a tough one. And I have to say, actually, after we've answered 10 questions, if I could pull way back from it, because I know there is one person in the room at least who still works for the Department of Justice, I think DOJ would say rights and property is broad. Rights and property means Congress wanted you to be able to protect your networks. Congress gave you free rein. They put vague language in there because they want it to be broad. They wanted to include porn. They wanted to include fraud. EFF is going to say the opposite.
And they said in their legislative history it was meant to preserve a common law defense for protection against fraud.
Granted, I'm just saying I feel obligated. There's this little DOJ bone in me that feels obligated to make it clear that DOJ probably would disagree a little bit with the advice, and they'd say it's a broad defense.
And he's probably right. I wanted to add an important point, though. In addition to interception, the acquisition of content, there are also laws governing the acquisition of non-content routing, signaling, and addressing information. So like header information. That previously only applied to dialed phone numbers, but it was updated in 2001 for the Patriot Act to include internet, because it's very easy for the government to get an order authorizing them to do that kind of surveillance as compared to a warrant. The problem is they expanded that to the internet without clarifying what that meant in terms of the civil liability for people who do it. And so right now there is a law that says you can't acquire header information unless you fit a very similar provider exception to the one we're discussing here. So all of the cautions we're giving you about acquisition of content would apply in terms of header information as well. If you're looking at it at all, if you're sniffing it at all, have a damn good reason.
Yeah, I've got that. Back, you're next.
So I had a question about, in terms of the consent, how specific that has to be. So I made consent to have my communications monitored, but doesn't have to specify, particularly in an organization, that they're going to, what they're going to monitor for. And if those circumstances change, do they have to come back to each one of those individuals? For example, today, or 3 years ago, there was no fishing, and now we're going to look for fishing. So I have to go back and get consent again.
Yeah, I mean, again, the court will ask a very simple question: what did you consent to? And if
But is consent accepted?
So no, and so consent comes in all sorts of different flavors. And so one rule of thumb I think I learned from Richard Salgado is the longer your banner, the more likely it's a bad banner, because you've likely filled it full of reasons that you'll monitor and adjectives and times a day and all sorts of other crap, when what we really want to see as the Department of Justice is one sentence that says you are being monitored for any reason, and we can use it for any purpose. Now, that's not going to fly in a university. That's not going to fly with AT&T. But that's what they want. The longer it is, the more
that's pretty much what AT&T's policy is at this point. I mean, really, you should all take a look at all of your policies, and you'll be amazed at how many of them basically say, we can and will monitor if we think it's appropriate,
for any reason,
without really anything more than that.
But to answer your question, yeah, caveats will be read. Everything will be read. So don't have them.
There's also, I was just going to say, there's also some great, if you're looking for language, there's some great sample banners on the DOJ website at cybercrime.gov.
So one thing you were saying during the defense's closing argument grabbed my attention, which was, we have 3 options that they might have done. The third one was not provide access to the internet.
Right.
And I found it really interesting that you said provide access to the internet as opposed to provide access to the organization's network.
Right.
Because it implies that the organization wasn't providing access to their private network, to their own resources.
They weren't,
were
probably.
providing access to the internet globally,
Yeah.
and therefore they weren't. And therefore, I mean, I guess you guys have probably intended to raise the question of net neutrality and what right to providers have to filter the internet.
I don't think we wanted to open that can of worms.
I saw it in the initial opening, and I kind of thought that's where you wanted to go.
Yeah, I thought where you were going with that is if they're just going out on the internet, what do you care? Why is it your right in property? And we intentionally did it that way because it stacked the deck a little bit more evenly. But I don't think we were going the other way.
The only net neutrality hook was the making fun of Stevens for the pipes thing.
Yeah, that's about it.
Okay, you mentioned private property, and I believe there's some debate now about your property, your home is definitely your property, and you've got your protection there. When you take your laptop out of the house, at that point it ceases to be private property.
I don't think that's...
The laptop is private property, but beyond that...
Yeah, it depends on what you mean by that.
It's no longer private.
Well, again, these are all open questions. You really have to put it in context. Are you talking about in terms of can the police search it? Are you talking about can someone grab it from you and not be considered a thief? But even with all these questions, you walk outside with your laptop, that's still your private property. If you leave it in the park for 2 weeks, yeah, it might change. So.
If you want to protect your own network, you can have a use policy that says our employees are not allowed to serve porn because it degrades the network. That is, we don't want
Yeah, certainly we could have, and in a case like this, we probably would have tried to make an argument like that. In a jury of 12 techies, I don't know if that's going to pass the straight face test. Maybe it will. I don't know.
It's going to be a jury of 12 grandmothers most likely.
But who knows? Yeah. Yeah. Sure. Yeah. So there you go.
John? I just had a quick comment.
Just speak up.
The employee's time spent watching porn instead of doing what they were supposed to do. Can you protect your rights and property in that sense?
Yeah, okay, so again, right, these are all other arguments in addition to the liability argument, which personally I think has the most appeal. That's the one I'd most want to be making. But these are certainly like, it's almost like secondary effects. There's lots of bad secondary effects if we let any big files across, and porn seems to be the one our people really like. So we're trying to stamp out that. Yeah, certainly.
One comment over here, and then I'll take.
Yeah, I just wanted to comment because I had to write policies for a company recently, and one of the criteria for web surfing that they put in there I thought was a bit unusual. They didn't want their employees to be surfing sites that were on the State Department's watch list, which I thought was rather interesting because they didn't want their network showing up on a State Department watch list. So they had a whole list of different types of sites that many were, you know, sort of terrorist sites or things like that. So just thought that was kind of interesting.
If my employee travels internationally, does my consent that I got from him still apply and connect back to my network? And
sure.
I know you guys are international lawyers, but how does the rule of consent apply in other countries? Are they all sort of generally like the U.S., or are they all totally different?
I mean, to answer your first question, yeah, I mean, if they're your employee, they're coming in through a VPN or something, they're still on your network. You could still do your monitoring. Honestly, to call out on someone, Richard.
If they're a citizen of another country, but they work for you.
Richard, I don't know if you want to talk, but Richard may have a lot more to say about what other countries have to say about consent. This is Richard Downing, who asked those probing questions a second ago. I don't mind if you.
It's all over the map, I think, is probably the answer. A lot of people don't even have rules on it, so it's really hard to tell. At least I have more exposure to Asian countries, and they're often uncertain.
Is that?
Maybe the European countries have much stronger data protection rules.
Is that part of the treaty?
Hell no.
Is that part of the cybercrime treaty? Are they trying to harmonize consent rules, or I don't know the treaty well enough.
In certain countries in Europe, your actual rights, you can't forbid the employees doing certain things. So in the Netherlands region, you actually have a right that you can't tell them what websites they have. If you're a French citizen and you sign away, you can't sign away your rights to do certain things. And if you haven't got consent, then as part of the employment rules, it actually travels with you to whichever country you travel.
The international angle reminded me of the intranational angle, which is, although with federal law, the consent of any single party to the communication is sufficient, there are a good number of states that require all party consent before you can intercept. Meaning that, say, if you had consent from your employee to intercept all their communications, that wouldn't help you.
So this
Actually,
is
wasn't there a case in California?
Well, this is
where
what tripped up. This, no pun intended. This is what happened to Linda Tripp. That she was in Maryland, I believe, when she was taping Monica Lewinsky, and that's an all-party consent state. And so the fact that she knew that she had the tape recorder on her wasn't good enough. She actually had to get Lewinsky.
Well, wasn't there a case just in the California Supreme Court just ruled on about a company in Atlanta that intercepted somebody recorded from California, and they have both sides have to consent.
Rick, you're
and
nodding
ruled
your
that
head.
they illegally.
You know this case?
Yeah, it
recorded.
was just the extension of the California Wiretap Act to say that it applied to an intercept that happened elsewhere, although one of the parties was in California. So it was typical, a state deciding that its laws actually extend, all the way around the world and back to the state again,
Which thank California for that.
Which there's a lot of states do.
Which working from Yahoo, you may not be a huge fan of that rule, but you don't.
Well, no, there's the decision goes through the analysis of the state's contact to the person and the interest the state has in protecting the rights of this person. It was a fairly lengthy, sort of thoughtful decision.
Was
Whether
the
you agree with
California
it.
Supreme Court decision?
I believe it was, wasn't it?
Do you all know the name of it?
I don't know what level.
But it was in the news like a couple of weeks ago.
Okay, I'll look for that.
It was a long-arm statute issue.
So, correct me if I'm wrong, because I don't really follow this that closely, but I
They are not common carriers.
They're not common.
Period.
So would it not be the responsibility of the administrator to monitor their network? Because if their network was then used for legal purposes, they would be liable.
I think you're confusing a lot of concepts here.
This is worth trying to straighten out, although sadly I can't straighten it out for you.
We're not
I don't really know telecom law. But there seems to be this perception that there are common carriers who have some kind of immunities that others don't. And it really has more to do with your regulatory status and what obligations you have.
And there's Section 230 of the Communications Decency Act, which has applied to lots of ISP non-common carriers, which gives them a free pass from all sorts of different liability.
Except for criminal and IP-based liability.
Okay.
But that applies to everyone, whether telecom or ISP.
And so that has nothing to do with whether or not you're a common carrier. It's a pretty broad immunity that applies to lots of different providers.
So would it apply in this case to their network?
Yeah, we sued him. I mean, he was brought. The charges were brought on him as an individual. So the question is, does he get to take advantage of the enterprise immunity? And hang on, I'm confusing everything. This is about their act. What we were talking about is the immunity for what other third parties do on your network. This is their act.
The
This is
Communications
his
Decency
act.
Act Section 230 basically says if other people are using your network for stuff, you're not liable for it, except that carve-out is limited. It doesn't count intellectual property violations. It doesn't count criminal violations. And so I've yet to see a case where it's even been attempted, much less successfully, to hold someone criminally liable for something that happened on their network that they were not aware of. And then there's particular safe harbors regarding IP. So,
how are they going to be aware if they didn't sniff?
The reason I ask this is that every use agreement I've ever signed with an ISP in like the last 5 years has basically said you accept monitoring. So obviously they're covering themselves.
yes.
So it seems like there's a legal pressure there for them to monitor.
No, it's more of a pressure to avoid liability in case they want to monitor or they screw up and accidentally monitor for an improper reason or whatever. But yeah, I mean,
It just covers them. It's
basically, yeah, it is ass covering.
If you can get your customers to agree to it and there's no cost in the market, then why not do it? It's just another layer of cover.
And sadly, there's clearly no cost in the market.
We had a question in the back.
Going back one, take your favorite two-party consent state. Has anyone tried using the argument that when you're sending an email, you're establishing a connection between your computer and only your ISP's mail server? So those would be the two parties that consent?
Yeah, and we hear these arguments all the time. We hear the arguments. Well, again, in 2001 with the Patriot Act, there was this new thing added called hacker trespasser. And I don't want to go into all the details, but one of the things that was debated is who are parties? Are all the little machines in between? And there actually is some pretty good case law, some of it surprisingly old, like these weird teletype systems in the 70s. And courts have said, yeah, I mean, it wasn't the most rigorous analysis, but they're like, party over here, the guy on the teletype machine, party over here, the guy who set up this server a couple of weeks ago. No problem. All party consent. So there's precedent for it, but it's like I said, not intellectually satisfying.
Yeah, I mean, there are strong arguments that they're simply not a party.
Yeah.
And if they were a party, it would make the federal regime in terms of the provider make no sense. I mean, the provider exception applies to telegraph operators and all these other people who are the kind of intermediary you're thinking of, but they clearly are not parties, or else they wouldn't need that exception because they'd be consenting to it themselves.
And there's a difference between email servers where you're issuing SMTP commands and routers where it's just passing. I mean, there's a lot of different ways you could spin that out. So.
Question in the middle here.
Thinking from the system admin angle, assuming the system admin wants to go to a company and they inception, he wants to protect himself. Assuming in this case, the system admin creates the program, he sets everything up, but he doesn't press the enter key. And he has someone else press the enter key.
Oh, no, that's...
There's probably a conspiracy argument there.
There's also... Actually, I believe the interception may actually be, maybe not. I mean, there's a catch-all section in the criminal code that says you have someone else do it on your behalf,
Yeah,
basically.
it includes the interception or procuring someone else to intercept.
So it's both in the statute itself and it's a catch-all. Yeah, that's not going to save you.
So, corollary to that, in the story, right, the CISO said, you're looking for someone else, he did not seem like a good candidate. Let's assume that he was not a good candidate because he did not agree with this, and they did not make him a job. So could he soon say, why should we do something criminal, and my refusal to do something criminal is why I didn't get the job?
Yeah, I don't know about that.
No, I mean...
I don't know what your cause of action is. You didn't hire me. I don't know.
No, I mean, if he did it
You
on
can
their
quit.
orders,
You can quit and stop making money. That's a attractive one, but yeah.
I mean, if he did it on their orders and then he got sued for it and sued for damages, he could seek to sue them to make them pay the damages.
Well, you might even have a, well, maybe.
Well, yeah, no.
Question here? No question? You had a question.
Well, I guess this is kind of a CY. You know, I mean, everything's going to him because he's the only guy that knows what's going on, correct?
Who?
And
To
so,
Brian, yeah.
So is it fair to say that they asked him to do something that was illegal?
No, because they were really vague about what they were saying. They were just saying...
They did not say sniff traffic, monitor this.
We could have set up the facts differently. We could have made this big, like Abu Ghraib, right? We could have made it, they just push down the responsibility. But we didn't. That's not the way we said it.
Because he did it?
So really, the only way that he could have got out of it was by not doing anything. Is that?
Yeah, and we understand where you're going with this. That's not a really attractive option, right? It doesn't necessarily work. You both may be committing a crime at that point.
Right, but then the employee is working under the direction of the employer. Therefore, he personally has...
Well, it might be a defense, but I mean, do you guys know about these cases?
This is one thing that if we had made that adjustment to the case, a minor adjustment, it would have changed the overall case considerably.
And they might have indicted the company, and they might have indicted the CISO and the system.
Right.
Richard, do you guys have something to add on that? If you're acting on as their agent, right, yeah, but we have this layer of immunity. Yeah, again, this is stuff that I don't, this is not my area of expertise.
But I mean, I wouldn't let the sympathy go too far in terms of my boss told me to do it. I mean, if your boss told you to murder someone, would that mean you should get off the, I
think this is a little grayer, though. I mean, this is...
a little, I guess. But, I mean, the basic principle, just because your boss told you to do it, does not get you off the hook.
Well, no, but the sympathy, I think, goes to what do you actually do? What do you actually do? And I guess what you do now is you say, I just got back from BlackHat, and 2 lawyers said that I'm committing a felony, and I'd rather not do that today. I guess.
No, I mean, what you're basically is like any content filter, anybody using content filter basically has to stop, right?
Unless they have consent.
But you're assuming that everybody on the network has consent.
You know what? The reason I love this topic is because everyone does this. Everyone's doing content filtering. Sometimes it's for rights and property, sometimes maybe not, but everyone's doing it. And so the question is, do you have the protection under this law? The government hasn't started indicting lots of people for this, but who knows? Maybe they'll get bored and turn to you guys now.
Just got another question on him. Is it his responsibility to know that everybody has...
Caleb, that's good.
Well, again, this was the same question we had earlier, right? I think that's not going to be a sufficient defense. It's not going to be enough to say...
I guess I'm just looking at a CYA kind of thing, and, obviously, everything's getting piled on him, buck stops there. Is he the guy that has to know that everybody says it's fine,
We might be blurring from the world of what does the law say to what's your jury appeal. If you can get up there and say, they told me that everyone consented, and they said that everyone was signing a piece of paper, and this guy didn't sign a piece of paper, how was I supposed to know that? You may not get indicted or charged in that case.
But there's a true separation of duties here, right?
Yeah, cut off debate. It's 8 o'clock.
Okay.
Someone else is actually
You got a better case.
fully responsible.
So for those of you who have been told by your employer that all of your employees and contractors are signing documents, I wouldn't worry. I wouldn't lose any sleep. Right? You're not about to get charged or sued for any of this stuff. But if they say it and you don't believe them for some reason, or you have a reason not to believe them, I'd start asking questions.
Like you weren't asked to sign what they say they took.
Okay, I'm going to have to stop the questions because it's 8 o'clock and they really want us out of here by 8. I wanted to thank everybody for coming. Please fill out your comment cards. If you really enjoyed the show, tell the BlackHat folks you enjoyed it. Thank you for coming.